in what it means. While they do that here, let us turn to our senior Washington correspondent, Hallie Jackson, there in D.C., to remind us all of what's at stake here. Hallie?
A lot, Craig, is the short answer to that question. It is both generational and also very specific. It is generational because it's possible that the Supreme Court will now set a new standard for presidential immunity moving forward for history. A legacy move here for generations to come yet. And specifically for former President Trump, it also obviously deeply matters to that federal election interference case against him. What the justices will decide as we are watching our team of legal experts there and correspondents hunched over their laptops sifting through this decision here. And let me explain what's at the heart of this case. Whether what the former president did as it related to the election interference scheme that he's alleged of conducting, were those acts unofficial or official? If they were unofficial, then his attorney concedes he could potentially be prosecuted for those. If they were official, he would, in theory, be immune to prosecution. That's the case that the former president's team is making. So let me give you an example. When the former president calls a private attorney, Rudy Giuliani, who then spread election fraud lies, his own attorney conceded that that would be a private, unofficial act. On the other hand, Mr. Trump calls the head of the Republican National Committee to talk about that fake elector scheme. His attorney insists that that is official. So that is what our team is parsing here. What specifically has the Supreme Court decided here on each of those matters? Now, the former president himself, in a new interview just released this morning that was taped yesterday, is seeming to downplay the impact of the immunity case against him. But remember why this is so critical. It is all about, and I'm talking politically here, it is all about the timing for him. His team is seeking to delay this as much as possible, past the November election, because that is the political reality here, that the former president could, in theory, end up back in the White House come January. In theory, he could potentially pardon himself. That is uncharted territory here, so we don't want to get over our skis on that front. But the timing is what is so critical. The judge in this case has said that she would not, in fact, move forward with the trial until about 3 months after this case gets back to her. We've been waiting on this decision coming down, not just on the very last day of this Supreme Court term, but the very last case on the very last day of the Supreme Court term. We know that politically, when the former president faces these legal issues, and they are in the headlines, that he gets a boon as it relates to fundraising. After his hush money conviction, remember, state case, not this case, very different. He raised something like $141 million in the month of May. We are waiting, obviously, to see any reaction from his campaign, Craig. We'll bring it to you as soon as we get it, but I have to tell you, it is my guess that they are doing the same thing that we are doing, looking through this decision, determining how it will, in fact, specifically impact this case against Mr. Trump, Craig.
And of course, Hallie, as we're having this conversation, there are a number of members in the Democratic Party, just 4 days after that mediocre debate performance, shall we say, already in a panic. One has to wonder what this decision could mean for the sitting president. For that angle, let us bring in now our Meet the Press moderator, Kristen Welker, also standing by for us there in Washington. So, Kristen, what say you to that? Again, I watched your show yesterday. We heard from a number of Democrats expressing myriad concerns about the current administration and the campaign. Any idea how this decision could impact President Biden's campaign come November?
Well, so far, we have not seen these legal cases really impact former President Donald Trump's standing. And again, as Hallie says, if the ultimate takeaway here is that the cases that have been brought by Jack Smith are delayed until after the November election, the impact could be that there just continues to be this focus on President Biden, his devastating debate performance. Now, it's worth noting, Craig, 62% of Americans say that Trump should not have immunity for actions that he took while he was in office as president. So that's a little snapshot of how the public sees this case. But again, in terms of the broader polling that we have seen so far, his legal battles have not dragged down his polling. In terms of what is happening inside the president's inner orbit, we know that after that debate performance this weekend, he was at a previously scheduled trip to Camp David. His family was taking photographs with famed photographer Annie Leibovitz. At that gathering at Camp David, they did discuss the fallout from the debate. What should next steps look like? We are told that the family has urged him to stay in this race, to fight, and publicly he's been defiant.
Kristen, stand by. Our crack team of legal experts, they've been sifting through this decision. Our senior legal correspondent, Laura Jarrett's been digging through it. 6-3 decision. What's the highlight?
Craig, we have here a landmark decision in American history as it relates to presidential power that will define the limits of that power for generations to come. The divided court now deciding here that the former president does enjoy some immunity. There is a dispute about how much and to what extent, but what we do know is that this case is now going to go back to the lower court for further delineation about what is immune, what is official, and what is not. The Chief Justice here accusing his liberal colleagues of striking a chilling tone that's disproportionate to what the court actually does. So you see a dispute here with the liberals saying that they've gone much further than the conservatives think that they actually have gone here, but they are saying that immunity extends to official discussions between the president and his attorney general, but they're going to put it back in the hands of the lower court, Judge Chutkan, the trial court, to determine what extent Trump's remaining alleged conduct is entitled to immunity. Remember, this is the case where he's been accused of trying to overturn the last election through lies and through fraud. He has resisted that and obviously denied any wrongdoing and has said that everything he did was completely within presidential powers, and that if you don't offer immunity to presidents, then they'll just essentially be handicapped into not being able to do their job, right? That there will just be a series of recriminations with the next administration prosecuting the former one. Again, the conservative majority here saying the president does enjoy some immunity, but there is no immunity when it involves unofficial acts. So say the president committed a crime, say he killed his wife or he robbed a bank while he was in office, that's not immune. But anything having to do with things that he was doing as president, as part of those official duties, the conservative majority thinks that is immune, and therefore it now has to go back to the lower court for more process, which means more delays, which really is going to have a big effect on timing of this case to be able to get completed and finished before the November election.
It sounds as if there's little to no chance that this case sees a courtroom before the November election.
I need to go through it. It's a lengthy opinion. I want to see what they say, if anything, about timing, because as of right now, I don't see them acting with any alacrity. I don't see the urgency here quite yet, but we're going to work our way through and see if they address that in some respect. And I'm sure the liberal branch of this, I'm sure, has something to say about timing.
Danny Savalas, I know you've also been sifting through the decision as well. What do you make of what we heard from the High Court?
At first blush, this is an opinion that you might read and think, oh, there is absolute immunity, so Trump is off the hook. But it's much more nuanced than that. In fact, the court takes a position that was actually conceded by the government on absolute immunity. And it essentially holds that there is a kind of absolute immunity, but only for core presidential functions. And Attorney Dreeben for the government essentially conceded that at oral argument. He didn't call it immunity, he called it something else, an Article 2 defense. But the justices said, look, whether you call it a defense or immunity, it's something. So the court does hold today that there is absolute immunity, but only for those core presidential functions. Think veto power, the pardon power, a very limited set of core presidential powers. Then we go into a second area, which is all other official conduct that is not that core presidential conduct. And for that, I think that's probably the biggest surprise here, is that there is what they call a presumptive immunity for all other presidential official conduct that doesn't fall within those official acts, those core official presidential functions. And then, of course, you have a position that was actually conceded by Trump's counsel, which is for purely private conduct. There is no immunity at all. So this is definitely one of those cases that once you read the first few lines and you see absolute immunity, you might think that, oh, Trump is completely in the clear. But that is not the case with this opinion. And in fact, even the holding as to absolute immunity for core presidential functions was something the government itself appeared to concede at oral argument.
Catherine Christian is an NBC News legal analyst, former assistant DA at the Manhattan DA's office. It would seem that this immunity case really did come down to what the president did in his official capacity after the election and what he did in a private capacity, shall we say, after the election. Was that essentially the thesis here?
Yeah, and looking at the glass as being half full, the court does say no immunity for unofficial acts. So is allegedly conspiring with private actors, private attorneys to come up with a false elector scheme, is that an official act? I doubt it. But there will be, again, we haven't gone through the whole hearing, but if this will go back to the district court, and if there's a hearing, that will be fleshed out. Will there be a trial before Election Day? I doubt it. 99% chance there will not be a trial. There might be this hearing to determine what were official acts versus what were unofficial acts, which the court clearly says there is no immunity for unofficial acts.
And Laura, not to disturb you while you continue to go through the nuance here and try to parse it, but to that point, the nuance.
Yeah.
Let's talk about the nuance here, because you've been predicting from the beginning that this would be a nuanced decision.
Because they're worried about not just Trump's case, not just the former president's case, but all cases of presidents going forward in the future, right? And so they kept bringing up the situation of the former President Obama and him ordering drone strikes on American citizens abroad. And the conservatives kept pressing. Are you saying, that would mean that you could prosecute Obama for having done something like that, ordering a drone strike? So clearly part of his duties as commander-in-chief, right? And I think that that's sort of like the thing that they were wrestling with is how do they make a rule that wouldn't just apply to the Trump case, but would apply to all cases going forward? And they seem to think that they have crafted that order. But of course, as it relates just functionally, as it relates to Mr. Trump, this is an enormous win for him because they've at least drawn some battle lines and said, at least on some things, again, his interactions with his attorney general, that kind of thing is immune.
The district court, this gets kicked back down.
Yeah.
That court will now use the guidance from the Supreme Court to sort of guide its decision.
And the ball is going to be in her court in a way that she hasn't seen this case for the better part of 7 months. Remember, everything has been on ice while the court was taking this up. And the special counsel, Jack Smith, had asked for the Supreme Court to weigh in on this so much earlier so that there would be a chance to get all of this done. He wanted this case done back in March. But of course, once the court took it up, none of the lower courts had jurisdiction. And so it's going to take a while, obviously, for it now to go back down to Chutkan. She's going to have to bring everybody in. They're going to get a chance to make their arguments. And then even at that point, say, she comes up with a rule on what remains of this indictment, right? And even if it's a little bit, if the former president doesn't like that ruling, he might then try to appeal that. I'm not saying he would win that. I'm not even saying the court would take it up. But he might still try to, again, keep the delays going.
Delay being the strategy. All right, stand by. I know you guys are still reading and sifting through. Our senior Washington correspondent, Hallie Jackson, joins me now once again. So, Hallie, I mean, here's the thing. President Biden has made central to his campaign the January 6th insurrection. This idea that re-electing Donald Trump would pose perhaps an existential threat to democracy itself. What does this decision, if anything, do to that argument?
It's a great question, Craig, and I'm going to get to it, but I want to get you a little bit of developing news coming into us in literally the last 30 seconds as you were tossing to me here. We are hearing now for the first time from the former president himself on his Truth Social platform. I'm going to read you his full post. It is short. It appears to be a reaction, obviously, to this decision that is out today. He says, "Big win for our Constitution and democracy. Proud to be an American." That's it. Those two sentences. Obviously, this question of whether it is, in fact, a big win for him is one that we are continuing to sift through. It is clearly at least a partial victory simply based on, as it sounds like, the timing of this issue here. And what's interesting here is what the former president is talking about gets at what we're seeing in this decision itself, the back and forth from some of the justices. For example, the liberals who dissented here, one of them, Justice Sotomayor, says that this decision makes a mockery of the principle foundational to our Constitution and our system of government that no man is above the law. And you are seeing in some of the liberal dissent this suggestion that the majority gave Donald Trump everything he wanted here. Now, obviously, the Chief Justice is pushing back on that, saying that that is not the case, that the assertion that the former president's team made went far beyond what the court ended up giving him. But the bottom line is this: the former president is interpreting this as a victory. As for your question on how this impacts the race and the central argument that the president has been making, President Biden against former President Trump, you're exactly correct that this is part and parcel of the character case, of the fitness case that the Biden team has been making here. You have heard some real criticism from top Democrats about the fact that they believe the Supreme Court took this case up, took as long as it did to get through it, waited until the very last day to come out and put this decision forward when there has been a sense of urgency, they believe, on this. And you have seen this consistently ever since, March, when this first came up here, this frustration with the way that the court has is decided here. You're seeing it in some of the liberal dissent. You're seeing it from those previous conversations and those previous statements from Democrats, fits into where the Biden camp has been on this all along. They have, remember, January 6th, they have tried to press this case. The topic of January 6th was one of just a few ads that the Biden camp put forward during that obviously highly watched debate on Thursday night, trying to make the case that because of what Donald Trump did in and around the 2020 election, in and around the insurrection on the Capitol, makes him disqualified to serve in office. The former president has downplayed this. In that same debate, he essentially talked about the world being respected on January 6th. He has defended some of the people who were arrested for going into the Capitol that day, Craig. I can tell you this. This decision means that that argument, this discussion of January 6th, it goes nowhere in this political campaign moving forward. Keeping in mind, of course, that voters have consistently said it is not necessarily what happened around the election fraud lies that is motivating their vote. It is much more those kitchen table issues like the economy, inflation, and immigration, Craig.
Back here in the studio, again, we should note the speed with which our legal team is processing and distilling this information. Quite remarkable from a non-legal guy. How much have we been able to glean from the decision so far, where this immunity, where it ends, the scope and limit of the immunity? Have we been able to glean anything about that?
Yes, we can take away broad principles, and you really could divide these into three major categories. And of course, my colleagues will tell me if I'm missing the point on this one. But really, you can say there is core presidential conduct for which there is absolute immunity. And then you have a circle which includes everything else that isn't that core presidential conduct, for which there is what's called presumptive immunity. Let's go back to that core presidential immunity, because there's a lot of really interesting factual determinations in this opinion, even though so much is going back down to the court on remand for determination. Here's an example. You may recall that in the indictment, there is an allegation that Trump met with members of the DOJ in order to allegedly get them to turn or investigate the election to benefit Trump. And he may have allegedly threatened to replace the attorney general with somebody else who would do his bidding. Now, that is a great example because the court says, look, you cannot look to his motive. As long as he is communicating with members of the DOJ, that is the president's core executive function, and he is immune for that conduct. And folks who may remember those allegations in the indictment, I mean, the circumstances, at least reportedly and as alleged, didn't seem to be investigating an election for the benefit of the election. They appeared to be for the benefit of Trump. And yet the court says that's the kind of thing that because it falls within the executive's core power, there is absolute immunity. Then they go through other factual determinations. And of course, you asked about the last area, and that would be purely private, not official conduct. And there is no immunity whatsoever for that. But in sending this case back down, they are sending it back down with some instructions and taking away some of the work of the lower court. And one great example of that is right here in the syllabus, that the DOJ communications, that meeting, that's the kind of thing that is core presidential conduct and therefore absolutely immune, even though the circumstances really didn't sound so good for the then President Trump.
All right, Danny, stand by. I want to bring in NBC News legal analyst Melissa Murray. Melissa previously served as law clerk to Sonia Sotomayor. And do stand by for me a second, Melissa, because your former boss, writing and warning in her dissent in part, when the president uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for pardon, immune, 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 immune. Again, those words written by Justice Sonia Sotomayor. What do you make so far of what you've been able to glean from the decision, Melissa?
So I've done a quick pass through the decision, Craig. I don't know that this is entirely neutral. I think everyone is correct that the court has decided here that official actions may be entitled to a presumption of immunity and unofficial actions are not. But this court actually goes a long way to delineate how certain aspects of the indictment against Donald Trump indicate official conduct for which he would be presumptively immune. So, for example, one of the things that the opinion specifically discusses are those conversations that Donald Trump allegedly had with Mike Pence to persuade him to hold up the Electoral College. The court here says that anytime the president and vice president discuss their official responsibilities, they are engaging in official conduct, and therefore those conversations, which apparently, according to Jack Smith, did not have anything to do with official duties, they are nonetheless part of the president's official duties because they occur with someone who is part of his milieu as president. And it is up to the government to rebut that presumption of immunity. So while this is going to go back to Judge Chutkan, and I think that it is exactly right that this will certainly delay the start of this trial, and we likely will not get a trial here, I think it is much more dramatic a sea change than some are allowing. This is essentially saying that anytime the president does something in the scope of the office, maybe even in we assume that it is presumptively official. And Justice Sotomayor is right. That is a huge sea change from what we have had in the past. And I think it is entirely inconsistent with the constitutional principle that the president is not a king.
Stand by for me, Melissa, as well, for folks who are watching right now, the right side of your screen. That was the scene that is playing out outside the courthouse there in Washington, D.C. right now. As you can see, a handful of protesters have gathered to protest the 6-3 decision from the Supreme Court that former President Trump is, in fact, immune for some official acts as president, not immune for unofficial acts. Let's bring in Jennifer Mascott. Jennifer is an associate law professor at Catholic University. She also previously served as a law clerk for Justice Clarence Thomas, and before that, she was a law clerk for Brett Kavanaugh before he sat on the High Court. Jennifer, thank you so much for your time as well. What do you make of the decision so far as you've come to understand it again as we are in the process of trying to parse through the various nuances?
Well, thanks so much, Craig. I think the court's decision today reflects the extraordinary and unprecedented nature of this prosecution. Here we have a presidential administration that's overseeing and supervising the criminal prosecution of the president's current political rival. And I think the justices in writing the decision today and in how they defined official act are showing that they're acutely aware that this decision is going to have impact on the scope and role of the presidency, perhaps for decades to come. And so how will this play out in the lower court? Well, as Danny and Melissa and others have been saying, acts that are within the president's core functions, and that can include getting advice from his advisors, but also things like the pardon power, appointing or nominating officials, but a relatively narrow subset of duties. Those he's going to have absolute immunity. So those are off the table for criminal prosecution. But there's this much bigger well of activity, official acts, which I see the court as defining as anything that the president might be doing while he's in office, where it could, unless it's clear, manifestly and palpably clear that it's a private act, there's a presumptive immunity. And what that does is it shifts the burden of proof actually to the government on remand in the district court to have to show that by bringing that prosecution for that official act, there won't be any burden at all on the role of the presidency. And so I think, as folks are pointing out, it will make the indictment and the prosecution below much more fact intensive. But the court has, I think, a measured decision here today, but also one that reflects the historic nature of the issues that were before it.
All right. Stand by for me again as we continue to look at the legal ramifications, potentially precedent that's being set here, potentially. Let us turn to the political side of this as well. Once again, Meet the Press moderator Kristen Welker joins me now. Kristen, I would imagine that responses are starting to come in from both sides of the aisle, lawmakers weighing in. What, if anything, are you hearing about what this decision could mean? Here we are, if my math is right, roughly 17 or 18 weeks out from a presidential election.
Well, again, Craig, as everyone has said, this will almost undoubtedly mean a delay in these cases that former President Trump was facing. We are getting our first reaction from the Biden campaign, Craig, and it gives you a sense of their thinking and their strategy moving forward. Let me read you a part of what they say. Quote, today's ruling doesn't change the facts, so let's be very clear about what happened on January 6th. Donald Trump snapped after he lost the 2020 election and encouraged a mob to overthrow overthrow the results of a free and fair election. Trump is already running for president as a convicted felon for the very same reason he sat idly by while the mob violently attacked the Capitol. He thinks he is above the law and is willing to do anything to gain and hold on to power for himself. That is significant. Why? Because, of course, that's been the crux of President Biden's argument for why he deserves another 4 years in office. He has tried to cast Trump as a threat to the nation's democracy, as someone who potentially runs the risk of carrying out yet another January 6th. And so it is clear that Democrats are doubling down on that argument and digging into that argument. But therein lies the crux of the crisis within the Democratic Party, that in the wake of that devastating debate performance by President Biden, questions swirling, outright panic within the Democratic Party about whether President Biden is the best messenger, the best person to take on this fight. I can tell you privately, Democrats are expressing concerns. One person saying to me he cannot win, another saying this race is effectively over. So, of course, the questions become, could he, would he step down? That process, incredibly difficult, incredibly challenging. And again, right now we have seen a defiant President Biden. Our Kelly O'Donnell reporting that sources inside the campaign are considering potentially more interviews, more public visibility. But that is really the crux of this crisis, Craig.
All right, Kristen, we'll come back to you in just a moment here. Again, we just heard from the dissent, Chief Justice John Roberts, also writing again here in part, at least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. The Chief Justice goes on to say, quote, the president enjoys no immunity for his unofficial acts, and not everything the president does is official. What can we glean from that? That seems to be, again, obviously I'm the only person at the table without a legal degree, but that would seem to be a bit ambiguous.
It is, in part because some of the things that he is alleged to have done, it sort of have a mix of a little bit of official and a little bit not official, right? And so it is clearly, if he's putting pressure on his attorney general really is there by virtue of the fact that he had put him there, right? Okay. So this is somebody who works at the pleasure of the president, effectively. Or if he's putting pressure on his vice president and putting pressure on him to disrupt the vote count in Congress. His vice president there is to, serve a constitutional role, but also really as a part of the executive branch. And so the idea being he can really do what he wants with his attorney general or his vice president. But when it comes to, for instance, putting pressure on a state official, right, calling the former Secretary of State, Brad Raffensperger, and saying, I want you to find me 11,000 votes. Right. That's where I think it gets tricky. And that's where I think she's going to have some work to do on remand.
Catherine, we were talking before we came on the air. Again, 6-3 decision here. Once again, falling down ideological lines. Based on what we heard during oral arguments about 2 months ago now, based on what we heard during those arguments, are you at all surprised that the decision itself was 6-3?
I'm a little surprised. Actually, before I said I hope that it was 9-0, and then everyone will have their own little concurrence. So I'm just a little surprised that it's defensible. Absolute immunity for official acts, presumptive immunity for, the quasi, and then none for the unofficial. But it's not a shocking decision because of the way the oral argument went. And Judge Chutkan, who moves very fast, unlike another judge, will, I think, try her best. There won't be a trial. I'll just state that emphatically.
Before the election.
Yeah. But there may be a hearing before the election. And then that's important because there will be people who will testify about the pressure that was put on them, allegedly. The Vice President of the United States may testify because even though the decision said that the pressure on him deserves some presumptive immunity, it still is a question whether or not that is protected. And then that's a factual issue that the Judge Chutkan will have to determine. All
right, legal ramifications notwithstanding for a moment, let's talk a little bit more about the potential political ramifications of this decision. And for that, we bring in Hogan Gidley, former White House Deputy Press Secretary from the Trump administration. We also have Simone Sanders Townsend, former Senior Advisor and Chief Spokesperson for Vice President Harris as well. I'll start with you, you, Simone, because, again, here we are just 4 days after that beyond dismal performance there from the sitting president during that debate, and now what would seem to be, potentially at least, more bad news for this administration. No?
Yeah, Craig, you know, I was in Montgomery County, Pennsylvania just yesterday, along with Melissa Murray, who you just had on, and we were speaking to black women in the suburbs of Montgomery County. And one of the things unprompted that they brought up was the Supreme Court. And juxtapose that conversation with what we're seeing from this decision today. This, and I'm seeing the statements from the Biden campaign officials. I really want to wait and see what the statement from the president officially comes from, the president's statement, as well as the vice president's statement around this particular question. You know, like Hogan, I worked at the White House. I was a deputy assistant to the president, senior advisor to and spokesperson for the vice president. And the staff, we are and also the families of the president and the vice president. We all get briefings about ethics and what is legal and what is not legal, and about our positions and how we should not be using our positions in a way that, frankly, is not in line with what we are there to do to serve the American people. And in reading this decision and just scanning it, it sounds as though, I mean, just the example that is given in the decision about having a meeting with the Department of Justice, regardless of what that meeting was about, that is an official act that is covered. That, to me, flies in the face of the guidance that the staff that work and support the president and the vice president, regardless of whom they are, get. And so I think I'm dismayed and really reading through and looking through the tea leaves from the perspective of someone who used to work in the White House. But politically, I think this just, those voters in Montgomery County, Pennsylvania, they were very well aware of what they felt the Supreme Court had been doing, how they felt it was overreach, and how that was motivating for them this November.
Hogan, we heard from your former boss a few moments ago. He put out a statement on Truth Social, starting what I would assume to be quite the victory lap. But here's the thing, Hogan, as you know, in the past, when legal decisions have come down that have not necessarily been favorable for the former president, he has been able to raise a lot of money off those decisions. It would seem as if this decision might make it a little more difficult to do that this time around.
No, I don't think so, in large part because of what you talked about off the top with Simone, which is the debate performance with Joe Biden last week, which is so abysmal. Listen, this court case, like so many others, really does have long-lasting ramifications, not just for Donald Trump, but for presidents in the future, and that was outlined by the justices in this opinion. Big win for Donald Trump, I would argue, but also a big win for the American people as well, in large part because of a section there which I noticed where they said, basically a common sense solution here, but they said the presumption of immunity applies to all occupants of the Oval Office. That's important because if it didn't, then attorneys on the Republican side would be billionaires by the end of the year for suing Barack Obama for things he did by droning American citizens or spying on Trump. They'd go after Joe Biden after he got out of office for ignoring law at the southern border as well. They'd go after Bill Clinton criminally for Monica Lewinsky, which never happened. This would be a perpetual system of massive judicial malfeasance for decades to come against former presidents for making those decisions. And one of the things I thought, Hogan, stood out to me.
With all due respect, is it fair to compare those aforementioned scenarios to the former president essentially asking an elected representative in the state of Georgia to go out and find me thousands of votes? Is that a fair comparison?
Well, let me ask you this. Is it a fair comparison to say asking someone to look for votes in Georgia where they had all types of instances of illegalities, irregularities, anomalies? You think that's not the same as Barack Obama droning and killing an American citizen? I would argue his issue is much worse than was Donald Trump's. So those are the issues that will not now be litigated moving forward because the court has ruled that presidents of all stripes have that presumption of immunity. But in addition to that, I found it fascinating that the conversations between any president and their advisors and the DOJ was also not admissible in court, and that you could not question or litigate, rather, the motives of the president. Because If you could, then as I mentioned, every attorney on the Republican side would go after every former Democrat president and say everything they did by definition was political, and you should be able to sue them and put them in jail. I think this settles the dust a little bit, and we can move forward knowing that the Constitution and the American people are way more secure now than they were just yesterday.
Hogan Gidley, you have been consistent after the appeals court decision was announced. I do recall you saying that you thought the whole thing was bogus on its face. Hogan, thank you. Again, Hogan maintaining there that this is, quote, his words, not mine, a big win for the American people. Is that, objectively speaking, is that a fair assessment?
Well, that's a political statement. So I'll just say it's a big win for democracy, and this is how it works. You go to the Supreme Court, you get a decision, and then you have to respect the decision.
This is a win for Trump in the sense that we can read this opinion and talk about even the facts that are identified. And I keep going back to that discussions with DOJ example. But no Supreme Court opinion can imagine all the possible factual scenarios that could come up. So now Trump's defense is going to make that argument. And keep in mind that as to the acts that are not core, for which there would be absolute immunity, but the other ones, the other official acts for which there is a presumption of immunity, Trump starts out in the winner's seat at the lower court. And I say that because the Supreme Court is going to require the government to prove it. They have what's called the burden. And you're often taught in the law that whoever has the burden is winning 9/10 of the case. The government has the burden to prove that this conduct is not official and therefore not entitled to immunity. So as Trump heads back down to the lower courts, his mission will be to describe all of the conduct in the indictment as being somehow official. And making that argument is not going to be an uphill climb for them because, again, the burden is with the government. So you can imagine that after this opinion, the Trump team is huddling and saying, how do we frame every single act in the indictment, in any indictment, as possibly tangentially official conduct? Because the court has now said you cannot look into the motive behind the decision. You must look at the conduct itself and say, is it official?
I think the real question for Jack Smith is what, if anything, is left of this indictment that's worth prosecuting. His entire project was to get this done before November 5th, because in the event that the former president was to be reelected, Jack Smith goes away. The whole case goes away. It's all gone. And so the sort of rush here, in Jack Smith's view, was knowing that he will be out of a job and this entire case and the classified documents case will be wiped out. He can still be prosecuted in Georgia, although that one is indefinitely on hold as well. He's already been convicted here in New York. But the federal cases, if the former president was to be reelected, they all completely are wiped out. And so I think the challenge for Smith is to see, is there anything left here that's worth streamlining to the extent that he even can? And that's not even clear to me that he can for all the reasons Catherine outlined. But to the extent that there's anything left here, is it worth doing to try to get done before he's out of a job if the former president's reelected?
I was going to say, and Trump's lawyers are going to fight to not have this hearing because that would require Trump to sit in a courtroom while she could be out campaigning. So you could expect they're going to argue that it should be adjourned.
Yeah.
All right. Well, big thanks to all of you here in the studio and to all of the other correspondents and contributors and lawyers who have joined me over the last few minutes. Again, for those of you who might just be joining us, in a 6-3 decision, the Supreme Court ruling that former President Trump is immune for official acts as president and not immune for unofficial acts. Of course, the decision will continue to be parsed through and sifted over for the next few hours. But for now, that's going to conclude this NBC News special report. We will have more on our streaming network, NBC News Now Online at NBCNews.com. And of course, a full wrap-up tonight on NBC Nightly News. For now, though, I'm Craig Melvin. Thank you for watching.
Good Monday morning. Thanks for joining us. I'm Joe Fryer. Savannah Sellers will be with me shortly. So let's recap this major breaking news coming out of the Supreme Court. On the final day of the term, in the last hour, the High Court issued this 6-3 ruling along ideological lines. It says former President Trump is entitled to immunity from criminal prosecution for official acts taken while he was president, but not unofficial acts. Now, this complicated case will now return to a lower court, which will have to decide what's official and what's not. Mr. Trump has pleaded not guilty to a 4-count indictment in the federal election interference case that was brought on by special counsel Jack Smith. Let's bring in NBC News legal analyst Angela Senadella for more on this. So, Angela, what, in essence, does this decision mean? This is going to go back to the lower court. Does the prosecution have the burden here to try and say, hey, this is official, this is not official?
Yeah, it does really appear they do. And we did get a lot of good guidance here on the differentiation between what could be unofficial and what is official. Here, the court explicitly says something so interesting, which is that we may not look into the motive of the president or the former president or whoever's on trial for their presidential actions in order to decide whether or not those acts are official or unofficial, because that is too intrusive. The second piece of guidance there between unofficial and official is that any sort of violation of a general law cannot be presumptively unofficial, meaning that just because the president may have seemed to violate some law or statute out there that is a very clear violation, that in itself also doesn't mean unofficial or official. So both of these two guidelines that the court brought down are pretty interesting in giving Trump some power here, that they're not going to look into his intentions, Joe. That's a big deal.
Bottom line, odds that this case goes to trial before the election are pretty much zero now, right?
That's absolutely correct, because the biggest question here of where there is any liability or immunity goes back and is remanded down to the district court. That's going to take a lot of time. Both sides have to prepare their own briefs, their arguments. Chutkan has to make a lot of decisions. And remember, back there, they can all be appealed again. So all of those decisions can continue to be questioned, Joe.
All right, Angela Senadella, appreciate your analysis this morning on this big decision from the Supreme Court. Thank you. Now to our other big story this weekend, or this morning, the July 4th holiday travel season, which got off to a big start this weekend. And this morning, the TSA is forecasting a record number of passengers are going to travel over the next few days.
And it is off to a chaotic start. Severe weather has delayed or canceled flights coast to coast, while a major hurricane is also threatening several islands in the Caribbean.
NBC's Sam Brock is keeping tabs on it all. Joins us from Miami International Airport. Sam, good morning.
Joe, Savannah, good morning. Chaos as usual in Miami. You know, you mentioned that it was pretty messy over the course of the weekend. 8,000 plus delays, guys, and this is the TSA has notched 3 of its 5 biggest screening days of all time in the last week or so. At the same time, you have a Category 3 hurricane, Hurricane Beryl, zeroing in on the Windward Islands, guys, with life-threatening winds and storm surge.
The July 4th holiday travel season is certainly off to a bang, with the early fireworks coming in the form of a barrage of storms nationwide. On Sunday, more than 8,000 flights across the United States were delayed and more than 2,500 canceled, as travelers got a taste of the hectic holiday crunch.
Our flight to Seattle was 7 hours delayed.
Ground stops Sunday were issued at all of the New York area's biggest airports, JFK, LaGuardia, and Newark, as drivers in Connecticut contended with flooded streets and tangled power lines. Out west, evacuations from flash flooding in Ruidoso, New Mexico, the same area